Today, we're discussing the question, what happens if my business partner wants out? This is such a common scenario, and it can arise for any number of reasons, from retirement to personal conflicts with other owners or key employees, to losing interest in wanting to pursue other ventures, to having personal or family circumstances that necessitate a change. Whatever the reason, when one partner wants to depart the business while the others wish to continue, it's crucial to approach the situation with a clear understanding of the legal, financial, and operational aspects involved. These are going to vary significantly with your particular facts and circumstances, which is why this video is intended for general, educational, and informational purposes only. You'll want to engage a lawyer who can provide you with actual legal advice based on your specific situation. But here are 5 big picture tips to get you started. First, reviewing the partnership agreement. The first step when any owner wishes to exit the business is to review the applicable governing documents. This might be a shareholder's agreement if you're a small, closely held corporation, or a partnership agreement, or, most likely, an operating agreement assuming your business is structured as an LLC. If you watch my past videos, you'll see that I'm constantly begging you to not just pull a random document from the internet if you need an operating agreement for your multi-member LLC, because you'll be bound by its terms, even if they're nonsensical or undesirable for your actual business partnership's needs. In an ideal world, you will have spoken with a business lawyer at the same time your ownership group was established, and this document will outline your genuine mutual agreements as to the procedures for what happens if a partner wants to leave the business, including the steps required for a buyout, valuation of the partner's interests, and how the remaining partners will move forward. Due to time constraints, I'm only going to highlight a few of the mechanisms that your operating agreement or other governing document might contain relating to an owner's departure, and I'm going to discuss concepts at the highest and most general level. These provisions are highly customizable to individual businesses and relationship needs, which is why you'll want to have a lawyer draft them in advance and review them as applicable to your interests before you invoke them. First, the terms of your governing document may prevent you from selling your ownership interests freely on the open market, and not just because there's a dearth of other buyers who would want to acquire a minority interest in your company. Business partnerships are often founded on a basis of trust between the original owners, and transfer restrictions keep one party from secretly selling the shares and thereby forcing the remaining partners to work with a total stranger. When transfer restrictions can only be lifted by, for example, a majority vote of the remaining partners approving the sale, they retain some control over who can enter the business and protect each other from unwanted external parties buying in. A right of first refusal can be a happy medium between total freedom to sell shares to whomever on the one hand, and absolute restrictions without unanimous approval of the remaining owners on the other hand. If an owner has a bona fide interest from a third party to buy her shares, under the right of first refusal mechanism, she must present the offer to the other owners, and they will have the right to match the offer and buy her out on the same price and on the same deal terms that the third party buyer would have done. The selling owner ends up in the same place financially either way, and owners who object to bringing in the third party can avoid the disruption by simply exercising their right to buy. This isn't a cure-all, though. The remaining owners might not like this if they don't have the liquidity to match the offer, leaving them stuck with the third party. Or if the governing document is drafted so that the third-party buyer still requires majority approval, or some other restrictions are in place and there's no real open market for the ownership interests otherwise, the wannabe seller can wind up stuck indefinitely. As a lawyer, I encourage buy-sell provisions under most circumstances because they can prevent the deadlocks that might otherwise occur. No one wants to think about this in advance, just like no one wants to think about a prenup or a divorce when they're about to get married. But they are an escape hatch when the reason the one owner is leaving is because working with the other partners has become untenable. In its most simple form, the owner that decides to pull the trigger will make an offer to the remaining owner to either sell her ownership interest at the offered price or to purchase the other owner's ownership interest at the offered price. This gives the owner making the offer a huge incentive to set the price fairly because the other owner gets to decide, is he selling his shares at that price or is he going to buy the offering owner's shares at that price? The offering owner has to live with that decision. This can be problematic if one owner is much wealthier than the other, in which case the rich gal can force out the guy with no liquidity at a price that is significantly less than the fair market value, since she knows that he won't have enough cash on hand to meet whatever cheapo price she sets. You can add in conditions that must be met prior to initiating this process to mitigate some of the impact. But especially if you've decided to include hefty restrictions on transferability or there aren't any willing third-party buyers, this may be a way out of an impasse when few other options exist. In many small and medium-sized closely held businesses, ongoing active engagement in the day-to-day operations of the company is a condition for continued ownership. This ensures that no one owner can coast on the hard work of the others without actively contributing to the success of the business. If a partner is no longer actively involved, whether due to retirement, a good faith voluntary resignation, or simply because he's sick of the business and he's hoping that if he blows off the company for long enough, the other partners will get fed up with him and do something about it, there may be mechanisms in place for the company or remaining owners to buy out his interests. Some agreements stipulate that if a partner ceases to be actively involved in the business, the company or the remaining owners are required to buy out those shares. The valuation and terms of the buyout are usually predefined to avoid disputes. In other cases, the agreement may permit but not require the remaining owners or the company to buy out the departing owner's interests. This is often used when a partner becomes less involved over time but remains a passive investor. The remaining partners have the flexibility to choose whether they want to consolidate ownership or to allow the passive partner to remain. Your business partner won't always affirmatively let you know that they're retiring or resigning, so clear guidelines are essential to determine when a partner is no longer actively engaged and what triggers the buyout. For example, a decrease in hours worked or a shift in responsibilities. The methodology for valuation of the shares at the time of the buyout and other payment terms should be determined in advance as well. Otherwise, disputes are inevitable. And note that while disability and death technically also would constitute a cessation of active engagement in the business, these events are usually dealt with separately and may utilize different valuation methods. Next, let's talk about the buyout process and the valuation of ownership interests. As I've alluded to already a couple of times, a major issue when a partner exits is determining how their interest in the business will be valued and what the buyout process looks like. There are several ways to determine the value of a departing partner's interest in the business. The book value method calculates the value of the partner's interest based on the company's assets and liabilities as recorded in the business's financial statements. But beware that book value can underestimate the true value of the business, especially for growing businesses, and sophisticated parties with a majority stake can sometimes use this to their advantage against less sophisticated minority interest holders. A more accurate method is to obtain an independent business appraisal to assess the fair market value of the business, which reflects what the business would be worth if sold to an outside buyer. This requires hiring an independent appraiser or business valuation expert, which is costly but often worth it. Some partnership agreements may already include a predetermined formula or method for valuing a partner's share of the business, which can simplify the process. This may be based on a multiple of factors such as revenue, EBITDA, or another agreed upon metric. Finally, some business owners simply agree that they will stipulate the value of the business, for example, at the beginning of the year at the company's annual owner level meeting, based on a supermajority vote or something similar. My practice pointer to you is that owners who put this into their agreements tend to forget to stipulate a new value each year. Half the time they don't even have the annual meeting. So you wind up with a stipulated value from 16 years ago and no alternative mechanism for determination. Regardless of the methodology used, once the value is determined, the remaining partners or the business itself must find a way to fund the buyout. Options include, first, a cash buyout. If the business has sufficient cash reserves, it can buy out the partner's share directly in a single lump sum payment. In cases where an immediate cash payment in full is not feasible, the parties may agree to buy out the departing partner over time using installment payments. Some partnerships use life insurance policies on key partners to fund a buyout in the event of a partner's death or incapacitation. There can be significant tax advantages to this approach when structured properly, and it can also turn into a tax debacle and a malpractice lawsuit when this is botched. If you want to go this route, it is imperative that you speak with advisors who have experience with split dollar life insurance arrangements, both economic benefit regime and loan arrangements, and don't let any old hack lawyer just wing this. Third, let's talk about the tax implications of the partner's exit. So another important consideration is the tax consequences of a partner leaving the business. Whether the owner is selling their interest, gifting it, or relinquishing it due to other circumstances, the transaction can trigger certain tax obligations. For example, since this is the sale of a partial ownership interest and not an asset sale, the selling owner will likely incur capital gains taxes on the purchase price amount received over their basis in the partnership. This can vary depending on how long they've held their interest. And depending on the entity's structure and any status elections that it's made for tax purposes, the departing owner may well still be responsible for their share of the partnership's income and tax liabilities until the date of the exit. In some cases, if a partner's interest is sold or exchanged, the partner may want to consider making a Section 754 election, which adjusts the basis of the business's assets to reflect the new ownership interests. This election can help avoid adverse tax consequences for the remaining partners, but it must be filed with the IRS in a timely manner. Chances are this is a question for your CPA rather than your lawyer. And indeed, the smartest move is to run the entire thing by your CPA as well as your lawyer before any papers are signed or any money is transferred, regardless of whether you're an owner that's staying or the one that's leaving. Fourth, let's talk about some default rules under state law. What happens if you never entered into an operating agreement or similar governing document? In the absence of an operating agreement, or if your agreement is just a shell of a document with a handful of irrelevant terms that you pull together to placate a bank or a landlord, then state laws typically will provide some guidance as to the owner's exit, depending on whether the business is structured as a corporation, LLC, partnership, or otherwise. These laws provide default rules that may not always align with the intentions of the partners, though, or they might not adequately cover the nuances of your situation, leaving you in legal limbo. So again, it's best to have a written agreement that overrides these rules. If you have to fight it out with no governing documents and ambiguous guidance from state law, it may take a while to resolve the matter. So remember, during this process and until the owner has actually withdrawn, the parties still owe a fiduciary duty to each other and to the company, including the duty of good faith and fair dealing. Any attempt to undermine the business or to misappropriate assets during the exit process could have legal repercussions. And yes, I have to say this for a reason. All right. Finally, let's talk about practical considerations and communication. In addition to the legal and financial aspects, it's important to approach a partner's exit from a practical and communication-focused perspective. I felt compelled to include the fiduciary duty reminder because I have, sadly, seen these transactions become very nasty and very litigious. This is a horrendous outcome for everyone, except for maybe the litigators who each make around $60,000 by the time the matter has been taken to court and then appealed. Open communication and good faith negotiations are essential to avoiding escalation. It's best to approach the situation collaboratively to ensure that the business can continue smoothly after the exit. But if one person is truly being an irrational arsehole and making progress impossible despite everyone else's good faith efforts, getting that litigator involved sooner rather than later isn't the worst idea. If the separation is relatively amicable, though, and depending on the role of the departing partner, a proper transition plan should usually be developed. This could involve the partner continuing to assist the business for a set period in a limited role, for example, under a transition services agreement to help existing client contacts adjust to the change, or by providing ad hoc consultation services for the remaining partners or the replacement owner as they adapt to new responsibilities. Lastly, ensure that all agreements, negotiations, and decisions are properly documented, including amendments to the partnership agreement, buyout terms, and valuation methods. Transaction documents should be executed prior to or contemporaneous with the payment of funds for the ownership interests. Otherwise, you could wind up with someone who is $100,000 richer and who 6 months down the road claims that the money was actually for something else and he's still a 30% owner. Show us anything that proves otherwise. And yes, I have seen that happen as well. So whether you have an operating agreement in place or you're relying on state law, whether you've agreed to the purchase price or you're still bickering about valuation methodology and payment terms, whether everyone agrees that the departure is for the best or one party feels like his hand is being forced, you really need the guidance of a lawyer. You can check out my earlier videos on this topic, but oftentimes this will need to be someone independent other than the company's lawyer, especially if you're the partner that's leaving. And don't let the lessons learned go to waste. Call them again when you need to get an operating agreement prepared for your next venture. Business owners, if you've terminated a business partner relationship, what were the most challenging, surprising, or frustrating aspects of the process?